Professor Porter. These are a series of videos introducing different topics in criminal law. We're at the front end of a criminal law course and really talking about parts of crimes. That is, before we get into specific substantive crimes, talking about the parts of any crime and starting to understand the component pieces of a crime. And we're covering the act today, the Actus Reus in Latin. Here's the parts of crimes. We're going to go over the different parts of them as we go through some of these different videos and as we talk about specific crimes. But as you can see, we're really talking about the two biggest ones are what did the defendant, what did the person get up in the morning and do? What was their conduct? What did they do? Or in a minority of crimes, what is the result they caused no matter what their conduct was? So it's either that the conduct is spelled out or that it's a conduct crime, or the result is spelled out, and that's what we call result crime. The most popular result crime is murder. We don't really care what you did or how you did it, but was the result, someone passing away, someone dying. So the act is first with some type of criminal intent, some type of requisite criminal intent called for in the common law or in the statute. Causes, some type of causation, particularly in a result crime, and a reason why we have the statute, a reason why we have the crime, some social harm that we're trying to prohibit. And we'll get into defenses as we talk about the course, without some type of justification like self-defense, or without some type of excuse like the defense of insanity. So here you see a couple ways that we would look at actus and look at the actus of a crime. And the two big categories have to do with conduct crimes and result crimes. So a healthy percentage of the majority of them are conduct crimes. That is, in the statute, in the penal code itself, it'll say what thou shalt not do. Don't touch, don't take, don't receive, don't possess. What the thing that you can't do when you wake up in the morning. A very minority of cases that have to be spelled out in specific ways that we'll talk about are those times when we can actually punish someone for failing to act, failing to do something. That can be because they have a certain duty or responsibility to the person, or also could be set out by statute that they should have acted and didn't. But for the most part, we're talking about conduct and what someone can't do, and it would be spelled out, and we're going to isolate it in our common law crimes that we learn. We're also going to learn to evaluate a criminal statute to be able to pull out what is the actus reus, what is the conduct that is prohibited. As I mentioned a slide ago, there are some crimes that are result crimes. That is, we're punishing that someone did something, voluntarily did something that brought about the result. The most popular one being murder or manslaughter, that they acted in a certain way that brought about that result. And that's always going to have with us a connection up to the causation. What did they do? How is that connected? How did that bring about the result that we're trying to prohibit? And there's other parts of statutes that we'll talk about that sometimes it's attendant circumstances. There are other things that need to be proven by the government beyond a reasonable doubt at a criminal trial, and sometimes those have mens rea elements to them as well, like knowingly doing something or not. But what we're really thinking about when we think about actus is isolating out that conduct, making sure that that conduct aligns with the other parts of crimes that we'll study, most particularly the mens rea. Now, when we look at a basic statute, this is federal bankruptcy, Title 18, United States Code 2113. And these are basic elements. This is what a government would have to prove if they brought charges of bank robbery against a defendant in federal court. And we'd evaluate it. And really what we're looking for is what does the statute spell out as the act required? And technically, when we're looking at a statute, it's usually some willed muscular movement. What did they knowingly and consciously do with their body to bring about? So here you see some of the actual actus parts of the case, right? The defendant took money. The defendant used force, intimidation, violence, that type of thing. So that's the willed muscular movement that has to take place. They had to physically take the money. And so we're going to be on the lookout, especially in our early learning here, of those times when it's not a willed muscular movement. Things like epileptic seizures, things like, where it's not controlled sleepwalking. The defendant's not consciously doing something with their body. That's not a willed muscular movement. So we're on the lookout to make sure, was it something they were actually physically taking and doing so, intending to move their body. And we'll draw some distinctions between some of the defenses like duress, where someone's someone's making them move, yeah, they're still, essentially having a willed muscular movement to do something. It's just someone is compelling them to do something with a gun to their head or something like that. So here we're evaluating the statute, finding the actus. This is a conduct crime, and you can see that there's two parts of it that are required for the conduct. And as I said earlier, we're going to learn about sometimes where failure to act might serve as the actus reus, but it has to be some special circumstance. It has to be imposed by a duty. It has to be imposed by a statute. There's different reasons why we may look at failure to act. For the most part, they're conduct crimes like this one, not result crimes like murder that we talked about earlier. And you're going to be able to isolate the actus, and you're looking for a willed muscular movement and not something that's essentially out of the defendant's control.